All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Thomas D. Sawaya, Judge presiding. All persons having business before this court draw near and give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Morning, and welcome to this session of oral argument of the 5th District Court of Appeals. Certainly our pleasure to preside over the three cases on the docket this morning. Let me begin by introducing the panel to you. To my right is Judge Jay Cohen, and to my left is Judge Wendy Berger. She used to be the junior judge on our court, but she lost that distinction, and I think gladly so, to our newest member of the court, Judge Wallace, who I'm sure some of you will meet later in other oral argument sessions. We have three cases, as I said before, on the docket. Through all civil cases, each side will be allotted 20 minutes. We have a clock on the podium that will assist you in keeping time. If the appellant wishes to reserve any time, let me know and I'll try and assist you with that. Please turn off any electronic devices, cell phones, etc., so that we will not be interrupted during the course of our oral argument. So with that, we'll take the cases in the order listed on the docket and begin with Hamilton versus State Farm.
Thank you, Your Honor. Good morning. May it please the Court. I'm Tom Elliott here with Trial Counsel Casey Williams on behalf of Mr. Hamilton, who appeals a summary judgment from a sinkhole that he experienced at his house. And for the purpose of this summary judgment, of course, we get the benefit of that disputed fact, and there is a sinkhole, and State Farm's denial of coverage for the sinkhole was wrong. I'm going to point out some differences in this and some of the other cases. I do think ultimately this case is controlled by the recent decision in Allstate v. Farmer, although we have some things here that are different, and I would suggest make the case even stronger for Mr. Hamilton, because here there was a denial in Allstate Floridian versus Farmer. There was no denial. Here in April,
denial of coverage.
I'm sorry?
A denial of coverage?
Here we had a denial of coverage, yes.
But then the letter also says that, we expect that you continue to comply with your requirements under the contract and provide us with any information that you may have so we can continue to evaluate the claim.
Yes, Your Honor, I'd like to address that. Oh, I forgot to say I would like to reserve 4 minutes for rebuttal.
Okay.
Sorry, thank you. Yes,
And before the filing of suit, even though an expert had been retained, the plaintiffs below didn't send anything to the insurance company letting them know that we have additional evidence that we'd like you to consider.
Well, it wasn't additional evidence, Your Honor. They did no more testing or anything. They had a letter that reviewed the earlier report.
They didn't send a copy of that report.
They did not before suit. That is correct. And it's our position that the summary judgment was wrong for 3 reasons, one of which is because there had already been a denial, there was no obligation for the insured to do those things under the policy.
What about this letter was a denial? I mean, they said that they had their engineer go out and look at it. The engineer didn't think it was related to sinkhole, and that basically, so we don't believe that it's covered under the policy. But let us know if there's any other information. So what about that makes that a denial?
Well, Your Honor, let's look at what the letter. First, let's back up. Let's look at the first letter that came out in April, acknowledging the claim. And that letter says, from State Farm, and it goes through, cites some different pieces of the policy, including some provisions that say, oh, you need to give us this and that. But when you get down to page 392 of the letter, it says, pursuant to the above, it doesn't say, send us a proof of loss. It doesn't say, here's the form for a proof of loss to fill out. It doesn't say that, which the Farmer case, the carrier sends the proof of loss form and says, fill this out. And they repeatedly, it's not filled out. And that is determined to be a question for the jury, not a summary judgment. But in this case, they never ask for the proof of loss. They say, if you have, present tense, have other information in the way of reports, investigations, so forth, send that to us. The insured had nothing like that.
But doesn't the insurance contract say you have to send the proof of loss in?
Yes.
Okay, so he was on notice he had to send it in within, 60 days of the date of the loss?
Right, and Your Honor, if that caused any material prejudice to State Farm, that would be a different issue. It's certainly, if it caused any prejudice, an issue for the jury. Here, State Farm made the denial. It didn't say we're denying because we didn't get your proof of loss. And let me get to the letter.
What about the decision in Starling, and if you get the full sight of it
Right.
from this court that basically says when you fail to timely file your proof of loss, that constitutes per se prejudice to the insurance carrier?
Well, Your Honor, in Starling, there were 5 requests for the proof of loss.
Right.
Okay, and this court's subsequent opinions, including the en banc opinion in Coran, which controls the decision of this court, and then the subsequent opinion in Allstate
Coran
v.
had
Farmer.
to do with a compulsory medical examination.
Yes.
And also this court, and I don't necessarily agree with that part of the analysis of Coran because I filed a lengthy dissent, but
I
this
know.
court said that was a condition subsequent, whereas in Starling, they say it's condition preceding. Does that make a difference?
No, Your Honor, in terms of evaluating the...
Because,
Right.
well, I mean, in Kern, if you want to rely on Kern, currently, this court in Kern certainly thought that was a very important distinction.
Right, and in the court's subsequent opinion of the 3-judge panel in Allstate v. Farmer, and Judge Berger, I appreciate you're not on board with that, but that is the most recent statement of this court. It's a 3-judge panel. It cannot be overturned by another 3-judge panel, as we all know. That would have to go en banc if we're going to reevaluate Allstate Floridian versus Farmer. And Allstate Floridian versus Farmer, you have multiple requests for the proof of loss. It's not provided. That's a question for the jury, not a summary judgment.
Well, I understand you there, but then ultimately, though, the issue becomes prejudice. And was State Farm prejudiced by not getting this proof of loss form? But the burden was not on State Farm to prove that they were prejudiced. The burden was on your clients to prove lack of prejudice.
Right, and that this record demonstrates ample evidence of lack of prejudice that would go to the jury. For example, we have State Farm denying the claim, and I'm going to come back, it is a denial with all due respect to what State Farm wants to argue. Let me pause on that. The June 20th letter, the first paragraph says, and this is a sinkhole claim, says the engineers have ruled out, have ruled out sinkhole activity. Then the second paragraph says, based on this investigation, there is no coverage. How much clearer could that be? There is no coverage. The other reason that this is clearly a denial of coverage is that the statute we've cited, 627.70131.5, says the insurance company must pay or deny within 90 days unless there are circumstances beyond its control. Now, at page 27 of their answer brief, State Farm tries to say, well, the insured concealed this stuff from, but so it was beyond our control. That's plainly wrong. The analysis that the geohazards provides is not until November, months later, months after the 90 days.
But the letter that you're referring to says, however, it is essential that State Farm have all available information that may be relevant to this decision. Therefore, if you have any information that may be relevant, including but not limited to expert opinions or reports, so on and so forth, please provide this information immediately so it may be considered.
Right.
And then it says that providing this information is requirement under the policy.
Right.
And when you say, well, it's have, it seems to me like that may be just parsing words and matters of semantics.
Well, Your Honor, are they parsing the words? They want to say they didn't deny coverage. We say that letter, when it says unequivocally there is no coverage, is a denial of coverage. So I would submit this is a jury question. The jury should hear all this. And State Farm wants to argue we didn't really deny coverage. We violated the statute by not denying coverage or paying within 90 days. That's got to be the argument. We violated the statute because we told you let's keep on going. They didn't deny coverage because they didn't get a proof of loss. They didn't say, hey, you didn't give us a proof of loss, we can't evaluate it, we're denying coverage because of that. They never mentioned proof of loss in their denial letter. They denied coverage because on the merits they determined there's no sinkhole. Now they're either right or they're wrong. If they're right on that, they're going to win.
So why not just send them the letter from the
Geohazards.
why just not send them the letter when you get it and have them do as the letter they sent your client said they would do and take another look at it?
Your Honor,
They never did get a chance to look at that until after the suit was filed.
Your Honor, when the suit was filed, when they got that letter, if that letter had made any difference to them, they could have said, oh, we're invoking neutral evaluation. Everything stops, they go to neutral evaluation. If there's sinkhole, if they decide to stand by their sinkhole denial, the case goes forward. If they decide, okay, oh, there is a sinkhole here, we're going to rethink it, then they pay then, and there's no exposure to fees for them.
Well, except that they've engaged in litigation at this and incurred attorney fees.
They could have invoked it right away, Your Honor.
Well, they didn't, but your client didn't give them that report until after the suit had been filed.
And they were not required to, Your Honor, for three reasons. First off, the denial letter is a denial, and the Indian River case says once the carrier has denied coverage, the insured does not have to comply further with the policy provisions. The denial relieves the insured of having to comply further with policy provisions.
If that's truly a denial.
Okay, and isn't that at least a jury question, Your Honor? Shouldn't we look at that? I mean, I think that that's a denial on its face, and it's clear as a matter of law, but at a minimum, shouldn't the jury look at that and say, well, when you get a letter that says there is no coverage, but then you include all its verbiage afterwards, is that being done because State Farm really wants to know, or they're setting up these defenses? Isn't that a jury question?
Well, can you answer for me their argument that it was your burden during the summary judgment hearing to prove a lack of prejudice, and that was, no evidence was put forth during the summary judgment hearing to show a lack of prejudice when it's presumed prejudice?
Okay, well, first off, again, if we're right on, these are three independent arguments. If we're right on that this letter is a denial, which is at least a fact question, then we don't even get to that question. Because if this letter is a denial, we didn't have to do anything further. So that's point one. The second point, as to whether there is, as to the prejudice question, as we pointed out in our brief, State Farm below never argued we were prejudiced by this. That wasn't the argument below. The argument was we don't even have to show prejudice. They were going into the Starling thing. You don't do it, you lose. Okay? With all due respect, at least in the context of this case, the Allstate Floridian versus Farmer says that's not the way we approach this. We look at whether there's prejudice. We look at whether there's a forfeiture provision in the policy. And that's the second point. Their policy, and they've never pointed it out to you, has no forfeiture provision. It has no provision that says if you don't tell us this, or if you don't comply with this, you forfeit coverage. They do not have that in the policy. The Indian River case, for our Supreme Court decision, says you need to have that. If you don't, the effect of not complying is not that you lose coverage, it's that you delay the time from which payment is due. That's a penalty to the insured. It makes sense. Things have been delayed. The prejudice question comes up when the carrier says, okay, look, we weren't able to do our investigation because you didn't give us this or that. Let's look at the time frame here. Their denial letter comes out in June of 2011. The insured has no report then. Nothing exists. They have no analysis of that report. They've not been asked. They've not been sent a proof of loss form. State Farm doesn't say in the denial letter, well, you know, we didn't have your proof of loss, so we couldn't tell. A proof of loss form in a fire, some of these situations where something's questionable, they want to ask, they want to take an EUO, that makes sense.
Eventually your client did send a proof of loss.
Yes.
Was that a form that they got from, your client got?
No, I don't think State Farm ever provided a proof of loss form.
Okay, but.
Once Mr. Hamilton got counsel, then they put together a proof of loss form.
Okay.
But you're asking a lay insured to do this when they have not been sent the form. Allstate Floridian versus Farmer.
Did they ask for the form? Did they say, hey, I noticed in my insurance policy I'm required to fill out a proof of loss form within 60 days of the loss. State Farm, can you please send me the form so I can fill it out?
No, I don't think there's any evidence of that in the record. State Farm sends a letter that refers to it, and then it says, pursuant to these provisions, give us this stuff. It doesn't say give us the proof of loss. It says, give us if you have any investigation, estimates, so forth. He didn't have any of that stuff. But getting back to your prejudice question, they didn't do a proof of loss form. We say they didn't have to because it was waived by State Farm's denial. But it's not material. When they talk about prejudice, what the cases are talking about is, was the insurer's investigation, in this case to determine was or wasn't there a sinkhole, was that prejudiced by the failure to have a proof of loss form? The insured does not know if there's a sinkhole. He sees cracking. He believes there is evidence of sinkhole, but he's not done any engineering studies. He has nothing. He turns it over to the insurance company. There's nothing in the proof of loss form that was going to help State Farm evaluate this. And that is clear when you look at their denial letter, which doesn't say you didn't give us the proof of loss form, and the denial letter sent 63 days after the claim. Proof of loss form is not due until 60 days. So even if he had done a proof of loss form, they would have crossed in the mail. State Farm was not relying on the proof of loss form. That shows there was no prejudice. And the prejudice, again, that the cases talk about is, was your investigation impeded? For example, in the roof cases, hurricane, 4 years goes by. Was the roof damage caused by the hurricane or things that happened in the 4 years? Timely notice makes sense there. That you can see how that prejudice comes up. The sinkhole is not going away. The sinkhole was there. If they didn't, if State Farm based its denial entirely on the work it did, it didn't say.
Did your client ever object to that report? You say, I don't agree to this person coming out here, and I...
No, he gave them full access to the property, he
Right.
complied in every way. The report comes in. The insured is not an engineer, he doesn't know. Months later, when counsel's involved, he gets a report that said, he gets a review of the report. It's not even any new data. They look at the other report and they say, this looks like evidence of sinkhole activity to us.
So you send that to State Farm and let
That
them...
would have been another way to do it, Your Honor, but they had already denied coverage by then. That's at least a jury question whether they denied coverage. We think it's clear. These cases are different. As I say, I do believe Farmer controls here, and it's stronger than Farmer, because in Farmer, it appears from the opinion, there's no denial. There are multiple requests for this, and that goes to the jury. The jury decides that. In the Starling case, the proof of loss requested 5 times, specifically requested. Here, never specifically requested. And, Your Honor, your opinion in Coran, I looked at that at some length, as you might expect when I saw you were on the panel, because I was saying, how do you reconcile, because you cited an old Supreme Court decision called Putnell. I said, how do you reconcile that with Indian River? Because Indian River's an old case, and it says, if you don't have a forfeiture provision in the policy, you don't get a forfeiture of coverage. They've gotten the trial court to rewrite their policy to give them that here. But when you look at Putnell and you get to the very end, after all that stuff about whatever demurs are and all that old stuff, you get to the very end, what they say is these issues are not likely to come up again on the next trial of this matter. That's because that wasn't a judgment in favor of the insurance company. It was a reversal of a judgment against the insurance company, and it's going back for a trial. The late notice, that's going back for a trial, not for an automatic summary judgment. So that reconciles with Indian River. Indian River says, if you don't have a forfeiture provision, you don't get forfeiture. If there are any
If you
further
want to
questions,
reserve the rest of your time, you got about 4 minutes
Great,
left.
thank you.
Okay. Morning.
Good morning, may it please the court. My name is Scott Samus. I represent the Appalachia State Farm. I want to start off on this allegation that there's no denial.
Why isn't he correct when he says that, I interpret that letter as a rejection of coverage, but then it's, well, wait a minute, and then it says, well, give us any information that you might have so we may consider it. Why isn't he correct when he says that perhaps it would be better for a jury to decide whether State Farm denied coverage and whether State Farm was prejudiced in this instance by not giving them the information under the policy?
Because just like in Starling and all of these cases, if you have a piece of paper, there's nothing for the jury to decide. The words on the piece of paper are the words on the piece of paper. It's like interpreting a contract. What is the legal import of what happened?
Apparently, if you take Curran and the Whistler case, it doesn't really matter what to me, I look at those cases and they say it doesn't really matter what the contract says. If there was a breach, then there has to be prejudice. So why wouldn't it be just a better matter for the court to say, let the jury decide all this. Let the jury decide whether State Farm denied the claim. Let the jury decide whether there was any prejudice to State Farm. Let the jury decide all that.
Because the facts in this case are undisputed. This is a Starling. In fact, this case is easier than Starling. Starling was a summary judgment. Fozzie was a summary judgment. Swaby, Edwards, all these cases where there is a condition preceding. I mean, Curran, you're absolutely right, Your Honor. Curran is a condition subsequent and does not affect this. In a condition preceding, the Macias standard, which is the most recent pronouncement by the Supreme Court, is there's a difference between conditions preceding and conditions subsequent. If it's a condition preceding, as Judge Berger observed, the burden is on the plaintiff to show lack of prejudice. There is no way to interpret this as a denial. In fact, they cite the Indian River case.
There are lots of ways to interpret that as a denial, because all the insurance company has to do is to write a letter saying, well, listen, you filed this claim. We're not going to pay you, but if something comes up, you let us know.
No, I think some context is necessary here, Judge. In a sinkhole case, the adjusting process, and that's what the suits against us provision and these conditions and proceedings are supposed to do. They're supposed to have an adjusting process before we go to court. The purpose of this adjusting process is to go out and scientifically determine whether there's a sinkhole. The legislature has taken the adjusting process and completely formalized it in sinkhole cases. If you get a sinkhole claim, the carrier must under 627-707 hire a geotechnical expert or a geologist and go out and perform a report which has to comport with 627-707-2 and 7.3 and issue that report. An adjuster can't go out and make the call. That report then has to be given to the insured. So what does State Farm do? They comply with the letter of the law and the letter of the statute.
Yeah, I know, but the letter that you sent out specifically says that, we've had this investigation done by Arena Engineering, and it says there is no sinkhole activity on your property, and then you say, and I quote, based on this investigation, there is no coverage in your above referenced State Farm insurance policy. Please refer to your policy as a whole with special attention to the following policy language. So you specifically told Mr. Hamilton that there's no coverage.
No, what we said was...
What is that? It says there is no coverage. I'm quoting,
No.
there is no coverage in the policy.
It says, based on this investigation, the statutorily required investigations. In fact, the statute says that the investigation done by...
Yeah, I know, but you may have a statutory requirement to go out and do an investigation, but then you say the investigation shows that there is no sinkhole activity, provide us whatever information you might have.
Correct.
But then you came out and said in your letter there is no coverage.
No, we said based on...
You didn't have to say that.
They said based on the investigation which is required,
But you have to...
there is no coverage.
Is there a statutory requirement that says that if your preliminary investigation shows there's no sinkhole activity that you deny coverage? That's not what the statute says.
No, because we did not deny coverage. What we did was inform the insured, as we have to by statute.
What are we supposed to do? What if I disagree with you and I say that's a denial of coverage? Then where do we go? Because there are cases that say if you deny coverage, that's it. They can go ahead and file the suit and proceed.
Your Honor, if this is a denial, then the statute says that there is a presumption of correctness in the claims handling process of this report. We have to inform them of the results of this report. What State Farm does...
You do not have to say, in addition to the report showing no sinkhole damage, that there is no coverage on your policy. That's not what the statute says.
It doesn't say that, but it would be dishonest to give the report to the insured and not say anything. The import of that... State Farm is informing the insured. The import of this testing that we did says that this is not a covered loss.
Okay.
However, we need to have all the information to make this decision.
How about saying at that point, based on this report, we do not have coverage. However, we are not denying your claim at this time. Please provide us with anything in addition that may help us in our determination of whether or not how we're going to treat your claim.
Well, I guess my response is that if you have denied the claim, and the language of Indian River and Progressive are that a denial must be, I wrote down, absolute repudiation of the contract. Absolute and unequivocal.
Okay, if you and I disagree on whether this is a denial, and we're both reasonable people, why not let the jury decide it?
No, it's the legal effect of this document.
Where is this a matter of law? I mean, we're interpreting a letter. You say it's not a denial. I seem to look at it and say that it is. It's a denial with, some exceptions. And the exceptions are give us whatever information, and we'll continue to consider.
Because
if we're interpreting a document like that, why wouldn't it be, and it can go either way, let the jury decide it?
Because the jury doesn't decide the legal effect of the unambiguous words the words in a document. It's just like a contract.
If it's a denial, then it would have a certain legal effect, and the judge would tell them that if it's not a denial. So maybe it's a question of fact, what you intended here. Intent is a question for the jury to decide, isn't it?
Well, I would submit, Your Honor, that if the standard is there has to be an absolute repudiation in order for the contract to go away, that the court should and can decide as a matter of law that this is not an absolute repudiation.
What about the Curran decision? Because I understand that Curran had to do with CMEs, and this is not a CME case. And Curran said that it's a condition subsequent, not condition preceding. Well, this certainly appears to me to be a condition preceding, especially if you read Starling.
Sure.
But Curran said that there was a breach, that there was a clear breach, but, there was no consequence to it because there's no prejudice that was established. And they disregarded the Macias standard that said that it's the burden is on the person that's claiming that there was a breach to show, and then it's up to the other party to rebut that. But in any event, they just said there's no prejudice. Well, what about Curran?
Well, in Curran, and the fundamental difference, and again, Macias says there is a difference between the conditions
I
preceding.
know, but Curran didn't, kind of rejected the Macias standard.
Well,
They didn't apply it.
right, well, I think
And they
that,
knew it was there. The majority in that case knew it was there. And they said, well, so what, there's a breach, but you still got to show prejudice. And there's no
Judge
prejudice.
Sawaya is still a little bitter about that.
So, I mean,
I don't blame him. He was the only one who was right.
no, I was the only one that was right.
And I wasn't on the court at that time.
Well, in any event.
I still
we
think I
have-
was right on that, but.
Curran is there, and then we have to apply it.
But Curran is there in the realm of conditions subsequent, and they're different than, because what controls this case is Starling. It is Judge Berger observed in the Farmer case. Starling is really what we should be looking at, and this one's easier than Starling. Here's the problem with Curran. In conditions subsequent, those are in cases that are liability-based. They're cases, they're liability cases. That's after where the court, there's going to be a determination of liability and damages that a carrier is going to have to pay. Then the insured has to cooperate in determining those facts. Conditions preceding arise out of the language. Page 1 of this policy says, we will provide this coverage based on your complying with these conditions. The word conditions means conditions. It means conditions in insurance contracts and
But
real
in
estate
Curran,
contracts.
it was a condition preceding the filing suit that you attend the CME. And this court said, well, that's a condition subsequent. So maybe this is a condition subsequent too.
Well,
Maybe Starling was wrong about that, I don't know.
If that's true, then the 5th ECA in Curran has somehow reversed the Florida Supreme Court.
Okay.
And itself in Starling. But here's,
Well, all right, go ahead, and I'll give you the
well,
last.
and I want to talk about the prejudice. So let's say it was our burden to show prejudice. The reason why these policies have conditions, and the reason why the suits against us provision is in there, which is reasonable, it's easy to understand, it's unambiguous, is that everyone recognizes that the adjustment process is important. It's important for the carrier, it's important for the insured, and it's important for the level of premiums in this state.
I know, and I agree with all that, I really do. But then, if you look at this court's trend in Curran and Whistler and some of the other cases, there's a trend that to me, from what I can see, that basically goes the way of, we got to be fair to the person that paid the premium, and we don't want the person that paid the premium to be deprived of the insurance coverage based on technicalities like this, and especially in a case where you send a letter that could be interpreted by them as reasonable people to be a denial of coverage. And based on the case law that they knew about and that I know about, they proceeded based on what they considered to be a denial of coverage and then filed the suit. And so there's a trend, it seems to me, to what's fair and what's equitable too. And isn't it grossly unfair in this particular case to deprive this insured of his coverage based on the facts and circumstances of this particular case and let the jury decide whether it's fair or not?
Absolutely not, and here's why, Judge.
Why?
Because if you look at Whistler's Park and Farmer, this trend that you're talking about,
Yeah.
look at the facts in those cases. Whistler's Park, the EUO was never said. Let me start with this. Why withhold the letter? If you really want the insurance company to look at it and adjust the claim, and you don't want to just create a lawsuit, turn it over.
What did they gain out of?
A lawsuit.
I know, but it looked like this was going to be a lawsuit anyway. I mean, you had your experts saying that there's no sinkhole coverage and that there's no sinkhole activity, and their experts saying something else.
Your Honor, it happens all the time. The initial engineer, the adjusters are not engineers. An initial engineer will go out, the insured many times, there's a word for it, it's called a flip. Another expert comes in and says, well, we dropped another boring here and we found a void. And you know what happens?
But these experts didn't do anything. All they did was
Right, they
say,
did a peer review.
we looked at your expert's report, and we don't agree.
Right. But that happens all the time. The reason why Whistler's Park talked about abusive EUOs and that EUOs are used as a trap. Farmer, the people sat for multiple sworn statements. EUOs gave tons of documentation. That's a case where people are trying and they're operating in good faith. In this case, if the simple and reasonable and straightforward conditions of the policy have been met, the adjusting process, which insurance companies hire entire departments to do to avoid court, could have occurred. But instead...
But that's the same thing that happened in Kern, and this court said that doesn't matter.
It doesn't matter for a condition...
It's still got to be prejudiced. And in Kern, the suit was filed, and I think in contravention of the specific requirements of the contract that said you cannot file suit unless you attend your CME and all conditions have been satisfied. And this court said that didn't matter either.
That's a condition subsequent. That's a condition subsequent. It's a different standard under the Supreme Court.
Let me ask you this. With regard to you've alleged that they breached the contract by not providing a proof of loss form. Was that form due under the contract before this letter went out, that they claim is a denial letter?
It's due within 60 days of the claim, yes.
Okay, so technically, so your argument is they breached even before then?
Well, they breached twice. They breached by withholding and concealing the report that they got, which we specifically requested. In fact, the request says if you have any expert reports, and by not providing the sworn proof of loss. So there were two. And the thing is, the reason why those are there is to flush out a disagreement. Let's flush it out before we go to the courthouse, because once we go to the courthouse, now they've got to hire me, they've got to hire trial counsel, everything slows down, everything gets more expensive. It does a disservice to the insured and to the insurance buying public in general to essentially for the court to write an opinion that says, you know what, we understand that these conditions are there, we understand that they're reasonable, we understand that they're clear, we understand that there's good reasons to have an adjusting process, but forget it. That doesn't do a service to anyone. This is an entire species. This action of withholding this information and then filing suit and then providing in discovery and providing the sworn proof of loss that you obviously could have done.
You could have moved to, did you move to dismiss the lawsuit based on failure to comply with a condition preceding under the policy?
No, the trial counsel moved for summary judgment.
Well, did you move to dismiss, I mean, if it's a condition preceding, and you have a clause in your insurance contract that says you cannot file suit unless all conditions preceding have been met, and you say it's a condition preceding because you distinguish it from Kerm, which we said is in a similar situation as condition subsequent. You could have moved to dismiss and this was the same argument that was made in Kerm. You could have moved to dismiss the case or abate it until these provisions were complied with, and you didn't do it, did you?
We did move to dismiss first because a motion to dismiss is based on the four corners of the document, and the lack of compliance was not within the
Well, you can
corners.
move to dismiss for failure to comply with conditions preceding, can't you?
No, I think that you have to do, because you have to introduce evidence. We want to get a final ruling. We have to introduce evidence. I don't think evidence is proper at the motion to dismiss stage.
Did you move for summary judgment, or did you move to abate until the condition preceding had been met? Or in your motion for summary judgment, did you say that the case should be abated or dismissed because condition preceding had not been complied with?
No, we moved for summary judgment because we had not breached the contract and the insured had breached the contract.
But you could have done that, couldn't you?
Right, but by doing that, the insurance company should not be obligated to waive the suit against us clause. It's there for an important reason.
I understand, and I agree with you on that, but if, and I don't know whether Kern should apply to this case or not, because Kern dealt with CMEs, but that's exactly what Kern said.
Well, Kern deals with a different situation. It deals with, which a distinction has been made by the Supreme Court. Has been made by the Supreme Court. Starling is the case that controls this. If Starling means anything, this case is easier than Starling. Starling, they had an EUO. This one is the concealment of something that was clearly specifically asked for. There's no, so we, not only do we
Okay, well, let me
deny,
ask you this. If you had moved to abate the lawsuit or moved to dismiss it, and I think you can file a motion to dismiss based on failure to comply with conditions preceding, and if there are issues of fact, well, then you can bring that up in a motion for summary judgment once depositions and all that have been taken, let the trial court decide that. If the case had been abated or dismissed, and then these conditions had been complied with, and then they refiled it, you wouldn't have had any prejudice, would you?
yes, because
Would you-
we've been
would be your
forced,
prejudice?
we've
Pardon?
been forced to litigate. When the contract is designed to prevent litigation until the adjustment period is over. If they,
And
if
the
they're,
court says, okay, we'll give you attorney's fees and costs for that part of the litigation where they filed it prematurely.
if there were a provision
How
like
much
that, that would be
prejudice?
wonderful.
Well, okay, what would be your prejudice there? What would you
If
have?
prejudice is defined as having to litigate, then, then it becomes meaningless. Every case would have that, wouldn't it?
No, not at all. When you violate the suits against us clause, yeah, I mean, if we're forced to go and hire a
Is it
lawyer.
yes or no? You're giving me, two answers completely opposite to the same
I
question.
think he may have thrown you a softball question. He said that it would render that language in the contract meaningless.
Yes, if it's a suit against us case, yes. If you have to litigate and then suspend and then wait and do your adjusting in the courthouse with all of that waiting, and then they can revive their lawsuit, and that's not the end of it. Then what we're going to have is an argument, all these arguments that we have now, we're going to have a Hill and Clifton hearing, and then we're going to get an argument and have to litigate whether the lawsuit made the insurance company do something they wouldn't otherwise do. So this is not just, they filed a lawsuit, no big deal, we can adjust the claim while we're in the courthouse. That is exactly the opposite of what was contracted for here. And no court has found that the suits against, in fact, the suits against us clause has been recognized and enforced multiple times, federal and DCAs. No one has ever said it's unconscionable, that it's unreasonable or hard to understand. This is a
Of course,
contract
if you've
case.
denied coverage, then that becomes inapplicable, does it not?
If there was an absolute repudiation of the contract, then that would be a different situation. I would submit that as a matter of law, there has not been. So we ask for a fine. Thank you.
Okay, thank you. Your time's about exhausted anyway.
Your Honor, as to whether there is at least a jury question as to denial of coverage, let's look at the Progressive case that State Farm cites, Menendez. It was quashed later by the Supreme Court, but not on this point. The letters in that case, if you read what the letters say, submit this information so you can be reimbursed. That's not a denial on its face. This one says there is no coverage. And you know what happened in Progressive? They reversed the summary judgment in favor of the insured, and they sent it back. It said, we remand to the trial court with instructions to have the trier of fact resolve the narrow question of whether Progressive denied or reduced plaintiff's claim.
What
Jury-
about the
jury
argument
question.
that Mr. Hamilton breached by not providing the proof of loss form before this denial letter came out? And therefore, if he breached on a motion for summary judgment, you have to argue prejudice,
Your Honor, we're happy to argue prejudice, but first off...
or lack of prejudice. I'm
Look,
sorry.
right. Their denial letter doesn't say we're denying because you didn't provide a proof of loss form. They didn't care about the proof of loss form to evaluate the claim. And prejudice means investigation, not did you spend more money, as Judge Cohen said. If the standard is you got out of the suit, every case would be dismissed, or would be summary judgment because the insurer would have spent more money. Prejudice means that it hampered your investigation. They didn't care about that here because all they cared about was their report that their hand-picked engineer gave them. That's what they relied on. They didn't rely on a proof of loss form from a layperson who doesn't know anything about sinkholes. So
Well, sometimes lay people will actually go out and get estimates, and they provide that in their
That-
proof of loss form.
that did not happen here, and that did not happen. I mean, one has to wonder, when we're talking about whether this is a jury question for whether there's a denial, I mean, I think it's clear on its face it's a denial, but it's at least a jury question. The jury can flesh out whether these other things State Farm was asking for in its letter, or mentioning in its letter, were they things they really wanted to evaluate the claim, or were they just there to provide them additional defenses when they moved for summary judgment? What were they there for? As far as the prejudice question goes, again, the no-suit provisions in all these policies. So they'll win every one of them. There's a little bit more expense, as Judge Cohen says, they win them all. There's not even, why are we even here? That's not what it means. The cases are very clear. In Farmer, you keep hearing about Starling. 5 requests in Starling. That's not what happened here. In Farmer, there is no proof of loss form filed. That is just like this case.
Do you think Farmer is your strongest case in your favor?
Probably, and from this court, the most recent and strongest, yes, in that sense, because there's no proof of loss form, there's no denial in Starling. Or, excuse me, there's no denial in Farmer. So Farmer is better for us in the respect here we have a denial. Under Indian River, we shouldn't have to do anything else.
Yeah, but in Farmer, I mean, I did dissent in that case, but in Farmer, I mean, the man had given, testified or given, testified under oath. He'd given all this information.
And here, Mr. Hamilton was never asked to testify. He was asked to give them access to his property, which he did.
And he was asked to give a proof of loss, to submit a
No,
proof of loss.
actually, Your Honor, the letters to him say your policy calls for this. It says pursuant, then they go and say, pursuant to these provisions, please provide us reports, estimates that you have. It doesn't say, please provide us a proof of loss. It recites it in the letter as something that's in the policy. They never asked for
He's
it.
not responsible for knowing what's in the policy or the contract that he signed? Is
Sure.
he presumed to know what's in there and what his responsibilities are with regard to his policy?
Let's accept that, Your Honor. Still, was there prejudice by him not giving a proof of loss form? Absolutely not here.
But the things that they asked for are the things that would be in the proof of loss.
Well, he didn't have any of that stuff. There's no
He made an
suggestion.
attempt to go get it and
Well,
provide it to them.
Your Honor, a layperson, is he supposed to go out and hire an engineer? I mean, the way, you just heard, the way the statute works, the insurance
did,
company's supposed...
apparently.
Later to dispute. But coming out of the box, you give your claim to the insurance company. They investigate and they give you a yes or a no. Here they gave him a no coverage, no sinkhole, no coverage. That's at least a jury question. We'd ask you to reverse.
Okay, thank you.